You talking about I'm being rude? I haven't even said nothing rude or disrespectful. I'm frustrated.
You are still yelling, and I've asked you a number of times to stop it.
Welcome back to the channel. Today, we're diving into a heated courtroom showdown that starts in a parking lot but quickly spirals into accusations of child endangerment, lies, and a dramatic sentencing. On one side, we have the defendant, Kelsey Salter, who insists she's the victim of exaggeration and misunderstanding. On the other, we have a furious mother who says Salter body-checked her child in public, then doubled down with shocking behavior outside the store. The judge isn't buying excuses, the lawyers are clashing over the facts, and the whole case builds toward a sentence that could change Salter's life. Stick with me, because we're about to break down every dramatic twist, from the parking lot altercation, to conflicting testimonies, to the final ruling. And trust me, you're going to want to see how this ends.
The defendant is not taking responsibility at all for what she did. She actually blames the child and the child's mother.
I don't know if this part is a discrepancy, but in the police report, when my client gave a statement, she said she did not mean to bump into the child. You know, she was rushing, and so this isn't some case where my client intentionally sought to assault a minor.
I mean, you read the parts that were favorable to your client, but here's the part that it says that you didn't read. The defendant did not apologize for her actions. She tried to justify what transpired. And the charge was hip checking a child, not once, but twice. I don't know how that is an accident. That in no way, shape, or form sounds accidental to me. Ms. Salter, what do you have to say today, ma'am?
Notice what just happened here. Salter is trying to soften the blow by apologizing, but listen closely, she never actually admits responsibility. Instead, she frames the entire situation as a misunderstanding, a horn honk blown out of proportion. But prosecutors are quick to point out the police report says she hit the child not once, but twice. That's a big difference. An accidental bump is one thing. 2 hits? That looks intentional. And here's the thing. In court, credibility is everything. If the judge thinks you're minimizing or dodging the truth, the punishment only gets harsher. What do you think? Is this just bad wording on Salter's part, or is she downplaying what really happened?
Just want to apologize to everybody that's involved. I definitely did not bump anybody twice. I walked past one time walking out the store. This went from me like beeping my horn to her making it seem like, I don't know. I really don't know. Well, I thought I was doing the right thing. I sat there and waited. I beat my horn and she sat there for a second, like didn't even acknowledge it was a whole line behind me on the main road. When I walked in the store, she was still on the phone being belligerent.
Anything else you need to say here today?
No, I just want to apologize the situation. Like, I don't be in things like this, and this is not my character.
And Judge, I don't know if the victim may want to speak.
She knew exactly what she was doing. There are witnesses. And I had opened the door for my son to come out. As my son was coming out, she clearly was in a rush. She clearly was agitated prior because even the witnesses outside were appalled by her behavior. She walked, body checked my child out of the line. I said to her, do not touch my child. We proceeded to try go around her to get back into the line, and she kept blocking us. It's appalling that someone would come after a child like that because they're so irritated over a parking spot or because they're in a rush.
The victim's statement is powerful. She doesn't just say her child was bumped. She paints a vivid picture of a woman fueled by anger, rushing, blocking, and even flipping her off after the confrontation. That's not the image of an innocent accident. And jurors or judges eat this up because emotional credibility from a parent defending their child is hard to challenge. Think about it. If you were in her shoes and your kid got shoved, would you stay calm? Probably not. And when she says Salter is only sorry she got caught, that line alone might weigh heavier on the judge than any lawyer's argument.
So when she says that she's sorry, she's not sorry. She's sorry she got caught. I got on the phone and I called the police. She went outside, flipped me the bird, got in her car and left.
Stories diverge so very much, but Ms. Salter seems to have been much more aggressive than it's even indicated in this police report. So if she's sitting here lying to me, the way it appears she might be, then I need to take a deeper dive into this because 30 days may not be enough. I don't like for anybody to lie to me or play games with me. That's a mistake. So why don't we adjourn this and get some deeper information on where we are with this case?
Your Honor, I mean, there's a possibility and that my client at this point would just want to withdraw her plea and move forward to trial, especially if we're going to take testimony from witnesses.
She can file whatever motion she wants to file, and I'll make a determination on that. Attorney Alexandria Taylor, please unmute your device and put your appearance on the record.
Good morning.
Can you please put your on the record?
Yes, Alexandria Taylor on behalf of defendant Kelsey Salter, who is present via Zoom.
Ms. Salter, please state
Yep.
your name.
Kelsey Nicole Salter.
All right, thank you. All right, we adjourned this matter. Ms. Woods, I think you were looking into some issues for me about whether the manager knew someone and what the behavior was.
That's correct, Judge. We have tried to contact the manager, Lindsay Bowen, several times. We have not been successful. And I just wanted the court to know, as I look through my notes, I believe that we did have a sentencing agreement in this case to no upfront jail and referral to probation. I know there was a recommendation to jail, and I did ask the court to follow that recommendation. But as I look through my notes, I realized that I did offer her no upfront jail, referral to probation, and under a prosecutor's deferred sentence, Judge.
And that is my understanding as well, Your Honor.
And my apologies for that, Judge. I do apologize for that confusion.
All right. I'm not sure the record reflects that because my notes do not. Defendant pled no contest to count 1 and count 2 was dismissed. Prosecutor's deferred referral to probation is what my notes indicate. I will honor that.
Thank you, Judge.
Thank you.
You're welcome. Anything anybody else wants to say today about this matter? I believe that we heard from everybody extensively last time.
We did, Your Honor. I don't have anything else, Your Honor. Thank you.
Ms. Salter, to you.
No, I just want you to give me a chance to show you that this is not who I am. This situation does not define my character. I'm a mother myself, and I don't condone anything with kids at all.
Thank you. All right. I will follow a recommendation with the exception of the jail recommendation. It is the sentence of this court that you serve 93 days in the Washington County Jail. Credit for 0 days served. The balance is suspended. So you won't have to do any additional jail time as long as you follow orders of the court.
Okay.
Here's where the legal hammer drops. Instead of jail, Salter gets 93 days suspended, 18 months of probation, over $700 in fines, mandatory anger management, counseling, random drug tests, and 0 contact with the child. This is what's called a deferred sentence. Basically, if she completes probation without incident, she avoids serving jail time. But the stakes are high. 1 slip-up, 1 failed test, 1 violation, and that suspended 93 days can become very real. And pay attention, the judge even warns her about lying in court. That's how close she came to harsher punishment. This isn't just about anger in a parking lot anymore. It's about her credibility and character moving forward.
You were on probation for 18 months, fines and court costs in this particular case for a total of $725. Meet with probation when and where directed, including any and all home visits. Make earnest efforts to maintain legitimate employment. Complete the anger management program with Crossroads. Engage in personal counseling and sign a release of information. I think you told us you're already in counseling, right?
Yes, ma'am, I am.
Okay. And so you just need to sign that release of information.
I'll do that today.
All right, thank you. No contact with the minor child, no assault of a threatening behavior towards him or anyone else. You submit to pay and be responsible for random drug and alcohol tests as requested by the court, probation, police, or any treatment provider. No use of possession of alcohol, marijuana. or any other illegal drugs, firearm components, ammunition, or other dangerous weapons. I'm going to do a review in 90 days on November 20th, 2025 at 10 o'clock a.m. I don't know if you plan to be back here, Ms. Taylor, but does that work with your calendar?
That does, Your Honor. And I have a quick question too with respect to the probation, because I know my client lives out county. She's like an hour and 20 minutes away. So would she just work that out, the frequency and how they meet with the agent?
It's done online. I think I may have skipped reading that. And that's
Okay. All right,
why-
perfect.
It's a report that she submits online on a monthly basis. Let me go back and read everything they said. I'm sorry, one second. Maybe it's not in here. It's not in here. So you need to submit your monthly reports online. There's an online platform, Ms. Salter, that you just submit the thing onto. And when you contact probation tomorrow, they'll go over all that with you so you can make sure you know how. I think what they actually do is send you a link via the email so you'll know how to make that report.
Okay. Okay.
Good
And
luck
I
to you.
appreciate you again. I won't disappoint you, I promise.
Thank you, Ms. Salter.
Okay.
And I will see you here on November 20th at 10 o'clock a.m., okay? And I
Okay.
should say out loud that, one second, she'll be eligible for early discharge once she completes half of this term. So
Thank
if
you.
she everything, she'll be eligible for early discharge.
All right. Thank you so much, Your Honor. Have a great day.
You too.
Okay.
Thank you.
And there you have it. A parking lot dispute that escalated all the way to criminal charges, probation, and a stern warning from the judge. What started as a horn honk turned into a child being shoved, a courtroom battle over truth versus lies, and a sentence that puts Salter under the microscope for the next year and a half. Do you think the judge got it right with probation instead of jail? Or was this too soft, given the victim's account? Drop your thoughts in the comments. I want to hear where you stand. And if you found this case as shocking as we did, make sure to hit that like button, share this video with someone who loves courtroom drama, and don't forget to subscribe for more jaw-dropping breakdowns every week.